Burden of proof and burden of evidence. Burden of proof is a duty of a party to present evidence to the fact in issue to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shift. Burden of evidence. Burden of evidence is a duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to other to the course in the proceedings depending on the exigencies of the case. Section 2. Conclusive presumption. The following instances of conclusive presumption. A. Whenever a party has his or her own declaration, act or omission intentionally and deliberately led another to believe a particular thing true, and to act upon such belief, he or she cannot in any litigation arising out of such declaration, act or omission be permitted to falsify it, and B. The tenant is permitted to deny the title of his or her landlord of the time of the commencement of the relationship of the landlord and tenant between them. Section 3. Disputable presumption. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. A. That a person is innocent of crime or wrong. That an unlawful B. That an unlawful act was done with unlawful intent. C. That a person intends the ordinary consequences of his or her voluntary act. D. That a person takes ordinary care of his or her concerns. Section 4. No presumption of legitimacy or legitimacy. There is no presumption of legitimacy or illegitimacy of a childbirth. After 300 days following the dissolution of the marriage or the separation of the spouses. However, alleges the legitimacy or illegitimacy of such child must prove his or her allegation. Section 5. Presumption in civil action and proceedings. In all civil action and proceedings not otherwise provided for by the law or these rules, presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption. If presumptions are inconsistent, the presumption that is founded upon weightier consideration of policy shall apply. If consideration of policy are of equal weight, neither presumption applies. Section 6. Presumption against accused in criminal cases. If presumption fact that establish the guilt is an element of the offense charge or charges a defense, the existence of the basic fact must be proved beyond reasonable doubt, and that presumed fact follows from the basic fact beyond reasonable doubt.